Good afternoon, everybody. Welcome to Litigation Finance, Funding the Law Firm of the Future. My name is Alexander Rufus Isaacs. I am second vice president of the Beverly Hills Bar Association and a member of the Litigation Section Executive Committee. You should have received the program materials by email about an hour ago. If for any reason you didn't, there should be a link to it in the chat box so you can download them from here. You will receive an MCLE certificate shortly after the program, and please take a moment to complete the survey that's included with the certificate. Now on to today's program, which is sponsored by Peter Pettit and Four Rivers Services, LLC. Rivers takes the burden of seeking third-party funding away from the law firm and ensures that lay clients receive the very best offers available in the marketplace for the funding of their disputes. Introducing our panel today, the moderator is aforesaid Peter Pettit. Peter studied at two of the finest educational institutions, namely Oxford University and City University London. He qualified as a chartered accountant in the UK in 1989 and spent 12 years in industry. In 2001, he became a corporate finance advisor working in the UK and Bahrain, and after working as CEO of a legal cost consultants, he moved to litigation funder Augusta Ventures and subsequently launched Four Rivers. Peter and his colleagues at Four Rivers advise clients on dispute finance in the UK and the USA. He spends time with funders as in an excellent position to advise law firm and lay clients objectively as to which are the best funds to engage on with specific cases. They establish competitive tension between the funds to deliver the best results for the claimant. Peter's also taking a part-time PhD at Westminster University on third-party funding, and equally importantly, he is a lifelong Chelsea supporter. Our other speakers are Carl Schultz, who is president of Schultz Haynes Love and Guth & Co., a Los Angeles-based firm specializing in litigation and forensic services, business valuation, and business recovery, which has just celebrated its 20th anniversary. Carl is a CPA, a certified valuation analyst, a certified fraud examiner, and is certified in financial forensics. He has significant executive, consulting, and ownership experience in a number of industries, as well as conducting fraud investigations and consulting and testifying on litigation matters. He's testified in a broad variety of business-related matters, shareholder disputes, alter ego and corporate governance matters, intellectual property, real estate, and employment-related litigation, and has testified as a qualified expert in numerous courts and arbitrations. I've used Carl's services myself as a damages expert, and I recommend him highly. Last but not least, William Mara is an investment manager at Validity Finance, LLC. Will graduated magna cum laude from Harvard College and Harvard Law School and clerked for Justice Samuel Alito on the US Supreme Court and also for Chief Justice William Pryor of the 11th Circuit. He was then a commercial litigator at Cooper and Kirk. Validity is a litigation funder. Will is responsible for sourcing investment opportunities from the country's leading lawyers and claims holders and is actively engaged in Validity's due diligence and investment underwriting process. He's spoken and written widely on litigation funding, and his article, The Shadows of Litigation Finance, will be published by Vanderbilt Law Review in spring of 2021. Sadly, he is a Tottenham supporter. If you have any questions for the panel, please feel free to use the Q&A function during the program. Don't wait till the end of the program, as we may run out of time. And in any event, the panel will be pleased to answer it. So with that, I have great pleasure in passing over to Peter, and I hope everybody enjoys what promises to be a fascinating program. Thank you.
Thank you, Zan, for that very kind and comprehensive introduction. And good evening to everyone from London, where it is cold, dark, and wet, which I suspect is very different to what you're seeing in Los Angeles. I'm very hopeful, very excited about today's webinar, and hopefully it'll be somewhat more successful than Chelsea's recent EPL form. But maybe we'll redeem ourselves over the weekend against Fulham. So I'm very pleased to be sitting here with Will and Carl. I think it's going to be a very interesting webinar. I'm sure a lot of you in the audience today have sat through some quite long and sometimes quite tortuous Zoom webinars over the last 9-10 months. We're going to try and make it quite different to that. We're going to try and make it a bit more fluid, a bit more flexible, a bit more interactive. And one way that we can achieve that aim is if you as the audience can send us as many questions as you would like to. There is a Q&A function at the bottom of your web screen. Please send your questions through as they arise to you. We'll work out when best to deal with them, and if we can't deal with them during the course of the webinar, we're happy to take them offline and speak to you separately. But that will certainly help the fluidity and the flexibility of the webinar. I think we'll probably divide up the webinar into two main sessions. One is the first session on what is litigation finance, who uses it, what does it cost, how does it work? And we'll look at that with a couple of examples in terms of single cases and how they can be funded. And then we'll move to what is potentially a very exciting area, which is portfolio funding for law firms. Because that, in my view, could well be the future. That could be you as law firms finding a great way to fund cases that you can take on a contingency style basis in a very lucrative, hopefully, fashion for yourselves. A very interesting source of capital, and we're going to talk through that and how that works in terms of numbers. And then right at the end, we'll probably just touch on some miscellaneous areas such as ethics and disclosure and the use of experts in testifying. And if there is any time left at the end, we'll have some general Q&A. So without further ado, litigation finance, what is it and how is it used and who uses it? I think I'm going to throw that first question to Will, because Will, as Zan explained, is one of the team, one of the Validity team, who are a first-class funder, very well reputed in the market, doing lots of deals. So Will, if we could start kind of with the basics here, what is litigation finance and how is it used?
Sure. Thanks, Peter, and thanks everyone for your time today. To Zan and the Beverly Hills Bar Association for hosting, and Peter for sponsoring. It's really a pleasure to be here and to talk about litigation finance. It's probably helpful to first start with a definition. What is litigation finance? We can think about it broadly as the practice where a third party provides capital to a litigant or a law firm in connection with a legal claim. Now, that's a pretty broad definition, purposefully so, because litigation finance can take a lot of different forms. It can be single case funding, which Peter already alluded to, which is an agreement between a funder like Validity and a claim holder to pay some or all of the fees and costs of litigation. It can look like law firm portfolio financing. That's an agreement, again, which Peter referenced, between Validity or another funder and the law firm itself. There can also be things like appeals funding, claim monetization that can allow litigants to realize today a portion of the judgment that they expect to get down in the future if the case is successful. Single case financing, I think, is the most common form today, and I think it's it makes sense to kind of start with here. And one lens that I like to use to think about and explain what single case funding is the following. Historically, if you had a good case, there were really two ways to bring that case. First, I'm talking about plaintiff side commercial civil litigation here. First, you could pay your lawyer by the hour to litigate the case. Now, the problem with that is not everyone has the hundreds of thousands or frankly millions of dollars that it takes to successfully litigate a commercial case. Alternatively, you could ask your lawyer to litigate the case for you on a contingent fee. The problem with that, of course, is that not every lawyer has either the capital or the risk tolerance to take a case on contingency, basically fronting the legal costs for their client in exchange for a share of case proceeds if the case succeeds. So single case litigation finance can be thought of as a third way forward, where the litigant doesn't have the money or doesn't want to risk the money to bring the case, and the law firm is unable to bring the case on a contingent fee, a third-party funder can come in and bear some of the fees and costs of litigation. So we won't make this too slide heavy, but it'll be helpful just to flash up this one slide that shows what a single case funding deal looks like so that you can kind of get your head wrapped around it. Scenario, your client calls you, they have a great case, but they can't afford to pay you. What a funder like Validity could do is we could pay 50% of the legal fees. So let's assume there's a $4 million fee budget. We can pay $2 million to the law firm. The law firm can invest the other $2 million of its time. On the cost side, which is basically anything that doesn't go to the lawyers, so everything from court filing fees to expert costs, people like Carl hiring your damages expert, Validity can share those costs with the claim holder. So everybody has something invested in the case. If the case succeeds, the claim holder is going to get, the goal is a majority of case proceeds, with the law firm and the funder sharing the balance. And importantly, litigation finance is non-recourse, which means if the case does not succeed, the funder gets nothing, right? So if you take out a bank loan to finance your litigation and you don't win the case, the bank is still going to come calling and might take some other collateral. That's not the case with litigation finance. And that's part of the reason that litigation finance has become so appealing, is you're really able to share this risk with a third party.
That's great. That's a very good starting point, I think, Will. And moving on really to the numbers here, because that was a very useful illustration on the slide. Clearly, to put a litigation finance deal together, the numbers have got to work all round. Being simplistic, if it was going to cost $2 million for a funder to put in the case, and there's no chance of recovering any more than $2 million, that's not going to be an economically viable case. So you as a funder, of course, are going to look for what you think is a likely recovery from a case, and then compare it with the investment you've got to make. So I'm really interested, and maybe bring Carl in here to look at how we get to that number. Is what is a case likely to produce in terms of cash proceeds? How can someone with Carl's expertise prove to you as a funder that actually the numbers are going to work? So Carl, could you give us just a view as to how you would start with a case and the types of methodologies you might use to value that claim?
Sure, absolutely. Thanks, Peter. As Alexander said earlier, we are a forensic accounting and economic consulting firm. We do some other things, but I personally am usually involved in a situation where there is a dispute, either as a consultant or ultimately economic or governance expert. We, like everybody, I'm sure, on this session, we get our business from two main sources. One is new law firms or litigants who are referred to us that we've never worked with before, or those law firms with whom we've had a working relationship over many years. With that latter group, we've long lobbied them to bring us in early, right up front, maybe even pre-litigation, when they are considering whether to take a case and when their prospective client is considering how to fund that case. An important consideration is, well, what is that case likely worth? I realize, of course, that there is a natural hesitancy to bring in someone like us early for fear, very well justified fear at times, that they will turn on the meter and start eating the budget before you even get out of the starting blocks. That's where the long-term relationship and the trust factor comes in. Counsel realizes that we're not in it just to generate fees, but to do something useful. There are a number of reasons, and I'm going to put up a slide which I may or may not exactly stick to, but let me just pop it up here. There. Can everybody? I think everybody can see that. There are a number of reasons why you want to bring in somebody like us early, and I realize there are questions, and you probably have questions about, okay, what does this do in terms of disclosure and discovery? And I think we have that slotted in for some discussion a little later on today, but I do have some thoughts on that topic. But in any case, clearly it helps if you are even in a pre-litigation situation or early stage to have someone do a credible analysis for mediation. Certainly, if it's a federal case, initial disclosures, the courts there usually want to see something more than a large number randomly plucked out of the air. And of course, potential retention of litigation counsel. What are they getting themselves into? They would like to know. And the topic of the day, litigation funding. In all of those situations, it has long been our contention that throwing up a large number doesn't help anybody if it's not supportable. And especially in situations where you are looking to either counsel to take on a case or to a third-party funder to put up the funds to pursue your case. The prospective litigant, the plaintiff, certainly has the best view of what their business or situation is and what the loss might be. But they also have a built-in bias. There's an emotional factor, so you're not likely to get, and they may not have the economic or accounting or financial experience to be able to effectively quantify what their damages are. They know they've been harmed, but they'll just throw out a random number, and that's not useful to anybody. If we're brought in early on a consulting basis, as I said, we've long argued that you want to be reasonable and realistic from the beginning. It can be a range. It doesn't have to be a solid number right from day one. But we try to get to the facts, which is really useful for counsel and funding sources in that you're going to see not only what the potential range of damages might be, but how supportable those calculations are. It serves to really distill a mass of data. I mean, we've had cases. In fact, we just have one ongoing now where we started downloading documents last night, and as we sit here, they are still downloading. It is well over 100 megabytes of information that we've got to wade through. Wading through that should not be the job of prospective counsel or funding sources. So, we argue to put together something that is not necessarily trial ready that you're going to go testify on, but something pretty darn close where you have a really supportable package and range of damages that can be evaluated by litigation counsel and potential funders. We'll talk, I'll probably stop here because later we'll talk about issues of discovery and what happens to that initial analysis and the third-party funders work in general. But anyhow, should I hand it back to Peter?
Sure. No, Carl, that's been very useful as a starting point. Certainly we'll come back to you on some of that. And just to let you know, we've had some very interesting questions on the Q&A about discovery and also about potentially defense side funding. I'd really like to take those questions a little later in the webinar because we have got a slot for them, but thanks very much. They're very, very pertinent questions. Just staying on Carl's point there about obviously valuing a claim, we've got to make sure it's a realistic number. As an advisor, I think my experience is always that the quantum side that Carl's expertise is very helpful with is one of the most neglected areas. And it's absolutely essential for a funder like Will to know that he's got a realistic damages number to start with. So that he can essentially work out whether the ratio of his funding to the potential damages claim makes sense. And Will, I was going to ask you a bit more about that. I mean, we hear rules of thumb in the marketplace of a kind of 10-to-1 ratio. Is that your current thinking, or have you moved away from that? That certainly used to be the case, I think.
Yeah, and that is how we think about it. And the key word here, I think, is fairness. Why does this matter? If you're the claim holder, if you're the lawyer, we don't want to put $2 million into a case where the expected damages are $4 million and the return goes to validity, right? There needs to be fair returns for everybody involved. At validity, we have turned down requests for funding from lawyers that gave their clients less than 50% of case proceeds, right? It is really important to us that this is the claim holder's claim, not Validity's, not the law firm's. We are simply helping you, the client, achieve your objective and helping the lawyer serve you. So what that means, to Peter's point, is there need to be some proportionality so that Validity can get its return, the law firm can get its contingent fee, but as with traditional contingency fee arrangements, the client's still getting half or more. So the typical rule of thumb, as Peter said, is 10-to-1. You typically want the amount of the investment to be about 1/10 of the reasonable damages amount for single case funding. And then I think, in addition to damages, and I think, Peter is probably going to have a lot of really interesting thoughts on this too. There's damages, there's merits, there's collectability, there's timing and jurisdiction. Those are all really interesting questions to put together that kind of total package. That's really the same way that your law firm or you as a lawyer are going to think about whether to take a case on contingency. So, Peter and I've really enjoyed working with him because he's always going to put that together in kind of a condensed memo with exhibits and things like that. And maybe you want to talk a little bit more about that, Peter, but those are, we're really looking for the range of issues that are going to come up in a case. No case is perfect, right? We understand that, everybody understands that, but you want to make sure that you've got a pretty good chance of success, right? We're not funding frivolous cases for sure. And that when there is success, everybody's going to be happy at the end of the day.
Yeah, I mean, it's a really interesting point because the way I always start with these cases is to look at four main areas, which you've actually just mentioned, Will, which is essentially the merits, the economics, the recovery, and the jurisdiction. Just going back to the merits, I mean, at the end of the day, I think it's fairly common practice that the law firm will be asked to put, I don't like the phrase, some skin in the game, but essentially you're backing your belief in the case by essentially investing some of your time, your billable hours in that case. And most funders, I think, and Will, I'm sure, is nodding, I know he agrees with this, like to see some kind of investment from the law firm in the case because it gives them confidence that there's a commitment there and a belief in the case's merits. So I think that's quite important. We talked about the economics. I mean, one of the things we do as an advisor is do quite a few spreadsheets showing what the claimant will end up with in different scenarios, because obviously there's a range of possibilities of outcomes. Things can settle, as we know, and therefore you've got to show the claimant that at each stage this is going to be his likely return. And I think it's very important, as Will says, that at any of these anticipated scenarios, the claimant ends up with a decent deal. You don't want people walking away from these deals with little or no part of the proceeds or the action. That's just not an outcome that anyone wants. So that's why the economics have to work. In terms of the recovery, in being very simplistic about it, obviously there's no point in going after a defendant who can't pay you. And I think in this hopefully rather unique time we're going through at the moment, these issues are going to become more and more relevant because clearly companies' cash may well be more strained than it has been previously because of the pandemic. And therefore, companies may not have the cash, whereas they did before, to pursue these disputes without third-party funding. And even if they do, they may well want to conserve that cash for their core businesses. So it's absolutely right that people should be looking at this as an option now. There's no real downside in looking at it as an option, I think. And jurisdiction, I think, is also an important point. Clearly, and we're talking about the US mainly here, so it's a reputable, track-proven jurisdiction. Here I sit in London, and we get a lot of different types of cases coming across my desk, some of which involve jurisdictions which frankly are a bit weird and wonderful, and not tried and tested. So we're probably not going to go there at the moment, but it's very important that the jurisdiction is a reputable one. So I think at the end of the day, those are the key factors that someone like myself has to try and distill into a memorandum or a paper that someone like Will can look at and get a very good sense quite quickly as to what the case is all about and how it's going to work.
Can I pick up, Peter?
Please do.
Sorry,
Go ahead. Sorry.
No, please do.
Go for it, Carl.
Yeah, just to build, before we move too far ahead here, to build on something that Will, you said, and Peter said as well. We'll do a damages analysis, and maybe a range of damages, but we will also pull together the support for those damages, which is important for everybody to know, because if you have $10 million in damages and a 20% likelihood of prevailing, everybody needs to know that up front. We will obviously not be able to offer an opinion on the legal merits of a case, but we can certainly look to things like, for example, if you're suing or potentially going after an entity that is part of an affiliated group or is a subsidiary group, often those companies are operated in a very thinly capitalized fashion, with all funds being upstream to a parent company who has ultimate control. So it's maybe important from day one to consider just who are the parties you want to throw the net out to, and make sure that you have all the relevant parties brought into the case. And that will sometimes drive an early attempt at settlement if a company knows that its parent company is roped into this thing rather than just their shell entity at the lower level. That's important to have knowledge of right up front.
Yeah. Will, please go ahead.
Yeah, and Peter, I just wanted to quickly pick up on your point about why people use funding. And a lot of lawyers might be asking themselves, okay, well, what are the situations in which it's appropriate for me to mention funding or discuss funding with my clients? There's certainly the liquidity constraint, which is how we normally think about funding, right? Circumstances where your client simply cannot afford the fees and costs of litigation, then it's sort of a no-brainer to mention funding. But what we've seen, sort of, you could call it almost a second wave, is what Peter alluded to, which is people who have the money but have a better use for it, risk constrained. You can think of them as that. Whenever a company wants to build a new restaurant or launch a new product or hire new employees, they don't always fund that from their balance sheet. And so what we've found is sophisticated companies, sophisticated litigants that have the cash on hand, but realize, you know what, I'm better off serving my customers and working on my products, building my widgets, than spending this on litigation. So let me have the funder and the law firm bear the risk while I can focus on my core business.
Absolutely. And I think Will, also one of the requests that we are seeing more and more now is where a cash constrained claimant is not just looking for funding for the cost of the case itself, but also some working capital so that it can continue to survive. And I guess that's quite important, isn't it? Because you need a healthy claimant throughout the process of the case, don't you? If the claimant is distressed or cannot attend hearings or give attention to the case, that's going to be a significant downside.
Yeah. No, that's exactly right. And funders are not controlling the litigation, right? These are not our claims. We're just funding them. So it's the law firm and the client need to be there throughout.
So this is one of the questions that has come up in the Q&A, and I think we'll take it now, as to what involvement a funder actually has once the finance agreement is signed and the money has been transferred. It's a really interesting point and something I'm covering in my own research, which is to what extent a funder can have involvement post-funding. And certainly in common law jurisdictions, which we're pretty familiar with here, of course, there are some limitations which are driven by the old legal concepts of championship and maintenance, which I would say probably die hard, those concepts, even if they have been watered down a bit. We'll come on to fee sharing and ethics a little later. But certainly the general trend is that funders don't have much involvement post-funding. And that's an interesting point because it contrasts quite a lot with private equity, which the private equity asset class has a number of similarities, I think, with litigation finance. But one area I think they differ is the involvement of the funder post the funding agreement. So how do you keep a track, Will, on how things are going on post-funding?
Yeah. We do not sit on the hypothetical board of directors of the case the way a VC or a private equity company would. We take the ethics super seriously. Any funder should. People like Peter are going to be able to advise you on that as well, as we know these issues. We do not control the litigation. We do not control settlement. Before we fund, we're all former commercial litigators. We try to, and we think we do, add value to the legal strategy. And we're there after we fund to be an advisor. But we're not controlling anything. We are kept up to date on what's happening in the case. But really, that's it. And frankly, our business model doesn't even allow us to control and be on top of these cases the way a lot of people are concerned we might, because we just have too many investments on, right? So we check in with lawyers, maybe it's monthly, maybe it's quarterly or something like that, see how the case is going. But it's really important to us, to our reputation, to the way that we do business, to comply with all of those ethics rules. And your serious funders are all going to do that. It's not just.
I think that's my experience. Just going back to the preparation of the case, we've had a couple of questions on this matter, and I'm going to throw this to Carl. Carl, you were talking earlier on about making an analysis for the potential value of the claim and the methodologies you would use. A very simple question, that initial analysis that perhaps Will would rely on, is that something that somebody's asking, is that something the law firm would pay for, or would the claimant pay for it, or what's your experience as to how you get paid for doing something like that?
Again, if counsel is already involved, there are times where we are actually engaged by counsel and only by counsel. Other times, and more often, it is the prospective litigant who engages us. And that's where, again, the trust factor, that comes into play, that we will not run up fees, but we will do what we need to do to give a credible presentation and analysis. So yeah, normally it is the prospective litigant who is responsible for paying us for that early stage work.
Yeah, another question that's come through the chat forum from John Floyd is a really important question. Is you make the commitment of money, and then there's a settlement, perhaps before all the money has been drawn down. How does that affect the original agreement? I think the question is really, what's the cost of the money at any point when the matter concludes? And clearly, my experience is that deal structures and pricing is becoming more diverse. It's becoming more innovative. Funders are really thinking carefully now about what suits this deal the best, what type of pricing. And I know, having worked with Will on matters, he shares that vision. But the old way of doing things, Will, was very much to charge a kind of multiple of the money depending on how long the case was out there for, how long your money was essentially committed for, or sometimes a percentage of the damages. Do you still start from that standpoint, or is there a different way of looking at that now?
Yeah, and these are great questions. I mean, if it's kind of the onion, these are like 4 or 5 layers deep, and they're just really good questions that lawyers should be asking. The deal should contemplate this important question. So at validity, for example, if we're going to seek a multiple of our capital, it's going to be a multiple of our deployed capital, not the amount that's committed, right? So you might have a case where we're going to commit $4 million to the litigation, but the case might settle early, right? And so at that point, if we only have, say, 2 million deployed, the multiple is only going to be on the deployed amount. Now, you have different return structures. A very typical one that you'll see a lot is the return goes up over time. So if the case resolves, say, in the first year, we don't get as high a return, right? Because we have not invested, we have not put as much capital at risk. And so in that circumstance, the client and the law firm get a greater share than we do. So our return goes up over time. And then there's sometimes a scenario that you'll see where it's the greater of a multiple of deployed capital or a percentage of case proceeds. So all of these kind of contemplate this, and this is a highly kind of considered question when we put the deal together. Again, with the guiding star always being, is it fair? And it's not fair for us, we don't think, to get a multiple of capital that we haven't even put out.
Yeah, so I think the answer to the question, and we could do a whole webinar on this, or a whole series of webinars, is that there are various ways you can do this. In general terms, obviously, if we follow the concept that a return has to match risk and it has to match the time value of money as well, then the longer the money is out there, the more the funder is going to want as part of his return. I think that's a pretty standard starting point. But I do think the deal structures have become more innovative over a period of time as I think the market has grown up, has matured, more people understand it. There are more players in the market. There's more understanding of how it works, and I think that's all for the good of the industry and the opportunities going forward. I'm conscious that we're now into the last 25 minutes, and I'm very, very keen to look at portfolio funding, and there's been some questions about that coming through, which we'll deal with. Suffice to say that in single case funding, and whether it's what Will's just described or a slight variant of that, essentially, normally the cost of that funding is going to be absorbed from the client's proceeds. So the client's going to be basically paying the cost of the finance. I think there are occasions from time to time, it's a very big case where the law firm might want to potentially have the money itself and use that to pay the expenses of the case and its own working capital. But in general terms, the claimant's going to be paying the cost of that. In portfolio funding, the dynamic's pretty different because you're looking at a whole basket and a whole bundle of cases, which essentially means that the numbers tend to be quite a lot bigger. But the great thing about portfolios, and I'll ask Will and Carl to give their views on that in a minute, is that the risk of the funding is much reduced because it's cross-collateralized over a whole number of different cases. And where risk goes down, of course, return will go down. So the cost of the funding is reduced. I know Will's got a slide to take us through on this, so that might be a good starting point. And then we can get into some more detail and then look at the ethics of fee sharing and other issues as well.
Yeah, sure. So I'm happy to quickly run through what that looks like. Here's portfolio funding. Single case funding, to just reorient us, is a contract between the funder and the claim holder. As Peter said, law firm portfolio funding is an agreement directly between the funder and the law firm. We are financing a basket of cases, 3 or more. It could be some of the law firm's cases. It could be all of the law firm's cases. It could be cases that are all about to start. Could be a mix of cases that have been going on for 1, 2, or 5 years and one that you just got in the door. Anything really, range of subject matters, all of that. What will happen with portfolio funding is the funder gives the capital to the law firm. That money the law firm can use for general corporate law firm purposes, right? We're not looking over your shoulder to make sure that you're using that money on the case. So law firms that we've done portfolio funding with have used it to hire new lawyers, to move into new practice areas, to expand geographically. So it's general purpose funding. And as Peter said, I think the 2 main advantages: 1, better pricing, right? With lower risk, because our funding is backed by the entire suite of cases, comes lower returns to the funder. The second piece, which I think is also really important, are lower transaction costs. So with single case funding, your client calls you, you then have to have the client make an agreement with the funder. When you have a law firm portfolio in place, all you have to do with your client is give them your full contingency fee agreement that they'll be familiar with and that they'll understand much more easily because it won't be as new to them. And then you de-risk on the back end through your law firm portfolio with Validity or whatever funder you're using. So a big reason when we started Validity, we thought 25% of what we do would be portfolios. It's now about half. And that's a big reason. Law firms realize that it gives them a big competitive edge in bringing on new clients who are looking for this risk share.
So this is a fantastic opportunity for law firms to basically raise the game, step up and be able to offer their clients very competitive fee arrangements. And as you said, the transaction costs are lower. I think the documentation is much more straightforward because it's the law firm signing one fee agreement with its claimant. There's no need for anything else beside that. So that's really good news. Now, again, let's look at the economics of this. If Carl is coming in and he's got to say value a basket of 10 cases as opposed to a single one, I mean, Carl, would you take any different approach because it's 10 cases, or would you apply basically the methodology that you use for a single case 10 times over?
Well, by and large, the same methodology, but the one factor that is important is the diversity of the claims. If it is reasonably homogeneous, yes, they can be lumped and evaluated. If there are some differences in the claim, one case to another, or they're entirely different, then you really need to look at it one at a time. Although when it comes time to valuing the overall portfolio, obviously portfolio metrics come into play there, since the risk factors are a little bit different. You are in effect generally minimizing risk a bit, and you need to take that into account in determining what the whole thing is worth.
So essentially, it's basically more of the same from your point of view, so that we can establish what the overall value of that portfolio might be. And then I suppose you look at that, and then you take some kind of rule of thumb generally as to what level of finance you would be prepared to commit based on the overall value of that portfolio. Yeah,
and with portfolios, again, the guiding star here being fairness. We want to make sure that the law firm's going to have a very healthy return, usually a healthy multiple of what validity is getting. We're usually going to look for the damages payable to the law firm to be about 5 or 6 times the funding amount. So, just one quick example that I think might be helpful to folks to think about. Well, how can this help me? You've certainly got the firms that aren't used to taking a lot of risk, that it makes a lot of sense for them to de-risk. But even if you're a lawyer who's used to taking cases on contingency, right? Let's say you have $10 a year to devote to contingency fee litigation. If you're doing a case on a full contingency, that $10 might spread across 3 or 4 cases. But if we come in and we share that risk with you, right? You compare your $10 with our $10, you can now take on 6 or 7 or 8 cases. So you're able to serve more clients while maintaining really the same, or in fact lower risk profile for the firm, because you have more cases ongoing. So we've seen that a lot, where firms that are kind of learning about funding for the first time, they'll say, you know what, Validity, here are our 5, 6, or 10, or whatever that number is, contingency fee cases that we've been doing for the past several years. Let's put them in a portfolio. And then going forward, as we have new cases come in, we can consider adding them to the portfolio, and you'll increase the funding amount going forward.
So this also dovetails into a couple of questions that have been asked by the audience, which I think are really pertinent. One of which was, as we mentioned, defense side cases. So actually, I think trying to do a single defense side case is really quite challenging. It's not something I've been asked to do very much. And I think without there being perhaps a pot of money that's been frozen that could perhaps be unlocked as a result of a dispute being resolved, and the funder taking some of that, it's very, very difficult, because there's not really a monetary award on defense side. But of course, if you include it in a portfolio, then you can absolutely fund it. And another question came in about pre-litigation disputes, such as royalty audits. Well, in theory, any matter that the law firm takes on could be funded out of this portfolio funding, couldn't it?
Yeah, that's precisely right. And that's what, it's so interesting, this space, because litigation funding has been around for maybe 10, 15, 20 years, but there's so much more to be done, right? There are so many new ways that we're still thinking of and figuring out to help lawyers grow their practices and to help claim holders with various different types of suits. So I think that's exactly right, Peter. And a lot of the most interesting conversations that I have are with lawyers who say, you know what, I have this interesting practice that might not fit your typical bill. Can we try to make something happen?
So there's a flexibility there. And of course, if you compare it with other types of funding that you might want to consider for your law firm, the traditional ones, of course, are partner capital, or it could be bank loans, they might have to have personal guarantees attached to them. Some of those types of funding aren't particularly attractive. What you're doing here is leveraging your essentially your success fees going forward. And I think that's very attractive because it's a non-dilutive source of capital. And as we've seen in Arizona recently, with everything beginning to relax, it's going to be a little bit like we have in the UK here at the moment. We have law firms that have been floated on public exchanges, raised money that way. We've had private equity investments into law firms. We've even had a litigation funder invest in a law firm here in London as part of the equity piece. Yeah. So I think you'll find in the US over time that things will open up and there'll be lots of ways of bringing new capital into your businesses. But portfolio finance is such an obvious one to consider because of the metrics that Will has pointed out. So I think it's a really important discussion that law firm partners should be having right now, actually, and we'd all be delighted to talk to you about that.
And Peter, to a question on that, it's all non-recourse. Right, so the funder's return is backed only by those cases. If those cases do not succeed, we don't have recourse to the firm's hourly fees or the firm's other assets, which is a big advantage over other forms of funding.
And I mean, there are funders in the market who will do recourse loans, but as Will says, this is non-recourse. So it's very attractive from that point of view. Conscious of time, and there's three areas I think we need to touch on before perhaps a Q&A at the end, if we have time. One is ethics, and this goes to the heart of fee sharing, whether that's permitted or not. The notorious Rule 5.4, which has been much written about recently, and certainly in connection with Arizona, and I know there's movements in California as we speak. Will, do you want to talk to that for a few minutes?
Yeah, sure. So the Rule 5.4 is the rule against fee sharing. Lawyers cannot share fees with non-lawyers. So the question that we often get is, well, wait a second, does litigation finance violate the rule against fee sharing? The first piece of this to recognize is Rule 5.4 is not implicated at all with single case funding, right? There, the agreement is between the funder and the client. So even those who argue that there's a 5.4 issue, they don't raise that issue in the context of single case funding. Very important to set the table with that. The question is an agreement between a funder and a law firm, does that violate Rule 5.4? As I noted earlier, we have done portfolios with many law firms, some of the leading law firms in the country, who've all recognized that 5.4 does not prohibit law firm funding, the same way that it doesn't prohibit law firms from taking recourse loans, shouldn't prohibit them from taking non-recourse investments. And we can kind of go into a lot of the reasons. I think one important point, just to give people some context for this, is there was a New York City Bar Association non-binding opinion back in 2018 that made the argument that there is a 5.4 problem with law firm portfolio funding. That decision, that opinion, non-binding opinion, contradicted New York State cases that actually approved of law firm funding. It created a pretty big uproar. The New York City Bar convened almost immediately thereafter this blue ribbon working group that issued in early 2020 a 97-page, I think it is, report robustly endorsing law firm funding, saying it's good for clients and their lawyers. And should be promoted, right? Because the purpose of the ethics rules is to allow lawyers to help their clients. So it's always something you want to kind of think about and talk through, and we can go through the details. I think the point that Peter raised about Arizona, California considering it, the working group considering it in California, I think is called the Access to Justice Working Group, which is an important point about why these are moving forward, why a state like Arizona got rid of Rule 5.4. And if you look at their materials explaining the Supreme Court, the state Supreme Court, why they did it, it's because they want to be able to increase access to justice and allowing litigants, right? If we think back to the two and now the third way to finance cases, litigants who might otherwise be locked out of the courthouse because they can't afford the fees and costs. their law firm can't take the case on risk. Well, they shouldn't have to lose their claim, or they shouldn't have to settle for less than the true value of their claim.
It's a really important area, but I think the trend is definitely one of more relaxed approach to this, and certainly, as I say, with the innovative approach of funders like Will to structuring things, deals should be possible. There may be some complexity around them, but deals certainly should be possible. We had another question which also spoke to some of the discussions we had prior to this webinar, which was about testifying and the involvement of an expert like Carl pre-funding and then post-funding as an expert. Carl, do you just want to talk about that for a couple of minutes as to how your role might differ from a pre-funding to a post-funding role and any potential conflicts?
Sure, just a few thoughts on that. One, I do believe in the end it is going to be protected under the attorney work product rule. This is pre-litigation. It's in a consultant role. Everything we do is marked confidential and preliminary, subject to change. So we should be protected. But even if somehow, if the same person or firm who prepared the initial analysis or evaluation is then named as expert and it does become discoverable, I don't even see that as a big issue because, again, it is preliminary. It's based on information essentially from the claimant's side only. It's usually before any substantive discovery has taken place. So by its very definition, it is going to change and evolve. So that should not be an issue. I never get, I mean, we're always careful, obviously, about sharing drafts, except in federal cases where it's permitted. But I wouldn't see this as a draft of anything, because you're not really going to be able to do an expert analysis until you have access to full discovery and all documentation that's available. So I don't see that as a major issue, but even if it does somehow surface, I don't think that segue from preliminary analysis to ultimate expert presentation is something that will become an issue for the expert in terms of impeachment, because it is an evolution from pre-discovery to post-discovery. So I really don't see it, but I do actually believe this would end up, there would be a strong argument to keeping this under the attorney work product privilege.
And the same is true with discussions with funders. So the great weight of authority is that funding documents and communications with funders are not discoverable. There are two ways in which this comes up. There could be mandatory disclosure or case-by-case disclosure. There are very few mandatory disclosure requirements. The one major exception is the Northern District of California requires disclosure of funding in class actions. Otherwise, what happens is during litigation, the defendant tries to access funding documents, and there are three independent and adequate grounds for why courts deny discovery. The first is they say it's simply not relevant, right? Rule 26 allows you discovery only of information that's relevant to the case. They say it's not relevant. Alternatively, they say even if it's relevant, it's protected, as Carl said, by the work product doctrine, which, as codified in Rule 26, is broader than attorney work product, or it's protected by the attorney-client privilege. So you really have three ways in which, by and large, courts are saying, no, we're not going to allow discovery into this. And I think what's animating that is a litigant who cannot afford the fees and costs of litigation should not be put to the pretty brutal choice of either not bringing their case or bringing their case at the price of having their communications, their private communications and strategy communications about the case disclosed to the other side.
Sure. And I should add, by the way, we've had a number of situations where we come in early in a consulting capacity and never evolve beyond that category, just to be safe. You know, we will more than happily recommend another expert to counsel to take it from there. You know, as long as it's someone who's not inclined to try to eat our lunch by stealing the client relationship or the counsel relationship. But yeah, we've had a number of instances where we then hand off to someone else who's going to take it into the expert realm.
Yeah, no, that's absolutely right. We've got a few minutes, and I just wanted to pick a couple of questions out from the very good questions we've had from the audience. One I think is very pertinent. How will the recent court closures and possible future Zoom jury trials affect the litigation finance industry? As a general point here, I mean, we as advisors, as I say, see many shapes and sizes of cases and at all different stages of development. Sometimes we see cases come to us from a claimant who hasn't even spoken to an attorney or an expert like Carl already, and we're actually charged with finding the right law firm and the right legal team and the right experts to take the case forward. We quite enjoy those opportunities because it's some currency for us to the law firms that we work with. But also, I think in terms of being able to shape the budget going forward so that it might mean a case is economically viable that wouldn't otherwise be economically viable is a great opportunity. And certainly my experience is, the last 10 months have been very difficult in many ways, but I think there's been a lot of, I read the other day that I think we've made 10 years of digital progress in 10 months. We're doing things like this now that we just weren't before, and deal management is being done now like this, whereas people aren't having to sort of get on planes or trains or buses to basically I think things become more efficient, and that will also result in cost savings, and that all essentially means there's less money required to run a case, which means it might be more viable and therefore the returns will be better. So I see things like Zoom meetings and blue jeans or webinars as a very good way of taking things forward. But I guess things like court closures, that's going to delay things, isn't it? So what impact do you see that as having, either of you actually on that one?
So for us at Validity, what we do is we help people pay their lawyers, and people need help paying their lawyers now more than ever. So in that sense, it's kind of been almost a vindication of the business model and why we think we're such an important part of the legal system to be able to help some folk. So we've seen a big increase in funding inquiries because of that, both with cases about to start and with cases that are ongoing where the client or the law firm simply can't continue to bear all the financial risk. And we've done investments of that sort. And then on the other side, of course, Peter, things are just taking longer. So our investments are out longer. And that's a risk of the case, right? Litigation can be very unpredictable, which is one of the reasons why people do want funding, because there are so many twists and turns, and a global pandemic is one of many.
Yeah. Carl, are you being asked now to do virtual testimony? Have you had some experience of that?
No, it's an interesting question. I have participated in a number of Zoom-based depositions, a couple of mediations, and 3 now arbitrations. And I have found them all really, really effective. I think you're right, Peter. We have discovered some benefits of technology that may not go away even once we come out of the pandemic. I think, especially mediations. I think mediations may just continue to be either in person optionally or via Zoom. I did see, I guess, Time Magazine named the founder, Eric Yuan, as the business person of the year, the founder of Zoom. So I do think Zoom will, or some follow-on generation of that will continue to be used, even for trials. I think it's a little cumbersome with jury trials. You really can't do that. But certainly bench trials may just happen virtually on a regular basis. When there isn't room in the courthouse, well, let's do it on Zoom.
Absolutely. We have hit 1:30, I think, your time, Pacific time. So our hour is up. There are a number of questions we haven't been able to get to, but I think hopefully Alex at the BHBA would be able to send those to us separately, and we'll deal with them offline. I'd just like to thank Will and Carl for being very, very good companions and good panelists. and I think engaging in, I think it was quite a fluid and flexible discussion. I'd like to thank Zan and his colleagues at the Beverly Hills Bar Association. And most of all, I'd like to thank all of the audience for coming to listen to us. We'd love to talk to you again about opportunities, and we're here as a sounding board. But main message is thank you for attending, and please stay safe and well during these very difficult times.
Yes, please.
Thank you. Thank you.
Thank you, everybody.